Hi, I'm Howard Snader. Today I want to talk to you about a question that I'm frequently asked, and that is, what do I say to a judge, or how do I talk to the court? In my world, in criminal law, that's called an allocution. It's a statement that you make to the judge. And there are a lot of ways that you can go to do things the wrong way. And several years ago, I had a situation where I had a client that had lost a trial. We won several of the counts, but he still lost, and he had to get sentenced on some of the lesser charges. At the time of sentencing, he was still protesting that the conviction was unfair, the jury didn't know what they were doing, and all the other excuses that are possibly out there in the book. But the bottom line is, a jury found him guilty. At the time of sentencing, I prepped him for the sentencing, and I said he had three options. And these will be the same three options that you have when you need to speak to the judge. Those three options are: one, you can say nothing. Number two, you can say, I didn't do it, the jury was wrong, and not be accountable in any way, shape, or form. Or three, since the jury has convicted you, go ahead and be accountable and make your statement. In a situation where you know you're going to appeal a case, you know something is wrong, you have a shot at winning down the road, my recommendation would be to say nothing. The one thing I would always tell a client is never, ever, ever go against the jury. Never, after a conviction, after you plead guilty, after you do anything, try and back out of it or blame others. So your two realistic options are either one, say nothing, or two, truly make an allocution to the court. When you make that allocution, when you make that statement to the court, there are several things that I want you to consider. You need to avoid cliches. Do not be overly apologetic. Don't be narcissistic or give an example of, I've seen the light, so give me a break type of speech. That apology, when you make it, it's got to be heartfelt. The judge has to know it's coming from you. If you're going to apologize to the actual victim of the crime, that's okay. The apology's got to be felt, though. And if you can't make that apology, don't. An example of a narcissistic statement would be the type of thing you might say, hey, I really want to see my daughter graduate from high school, or I really want to walk her down the aisle. Those are nice statements, but those are things you should have been thinking about at the time that you committed the offense. I've seen the light speech comes up frequently where, if you give me probation, I'll guarantee you'll never see me again. Or I will talk to high school kids or counsel other people never to go down the road I went through. I would like to believe it, and quite honestly, my clients might believe that that is a valid statement to make. But until you've gone down the sentencing path, until you've gone through the counseling, until you've done the things that you need to do to put yourself on the right path, I'm not sure it's a sincere statement, because you really don't know how to fix yourself, let alone fix others. What you can make a statement towards is saying you'll accept the recommendations of probation, you'll accept the recommendations of counseling, you're open to what they might want to throw at you. When you make your statement, I really need you to focus on not necessarily what you say, but how you're saying it. It's got to be short, it's got to be concise. An apology, as I noted before, is always appropriate, but it's got to be sincere and come from the heart. In a lot of times what happens when I get clients thinking about that, they become emotional. That's okay too. In fact, if you get emotional, if the tears are flowing, that really sends a statement. It's not acting, it's got to be real, but don't hold it back. Don't be the big macho person and hold it back. This is the one time in your life where everything is riding on the judge deciding what your fate will be. Let your emotions come out. When you want to when you want to make a statement, you can do it a couple different ways. I have some clients that are very good at just speaking, just what we call extemporaneously, just off the tip of their tongue. A lot of clients are going to get stressed out. The weight of the world is going to come down on them, realizing that this one person sitting with a robe on the bench is going to decide their fate. And they get flustered. So I do recommend that you jot some notes down or write an actual statement to the judge. If you're going to do that, I recommend that you write the statement down in a way that you're comfortable repeating it. For some people, it literally is reading the statement to the court. Your allocution can be 10 seconds long, it can be 10 minutes long, it can be an hour long. I did have a client go about 40 minutes. That's extremely rare. Most statements are between 1 and 3 minutes. That's a long time to talk. So it's not a question of how long it takes or how short it is. It's a question of the quality of the statement that you make. You can't have any excuses. It really pains me. When I sat as a pro tem judge, it pains me when people come forward at the time of their sentencing and say, I made mistakes. Normally, the conduct that you've been accused of is not mistake-driven. Usually, it's because of a poor choice. And there's a huge difference between making a mistake and a series of poor choices that let you to stand before the judge. So rather than speak in terms of mistakes, please consider it a situation where you've committed multiple poor choices, and why did you commit those poor choices, and why you will not commit those choices in the future. There are no good excuses, there are no rationalizations. You just have to sit there and be fully accountable and understand that you may not know why you did what you did wrong, and again, that leaves you vulnerable. It leaves you open to saying, I know I need to be punished, I'm looking to be punished fairly, and I'm looking to understand why I did what I did so I won't do it again. You say something along those lines, counseling is an appropriate outcome. It's really hard for me to sit here and tell you how to go through the statement other than what I'm just saying now. The more time, the more thought you put into crafting your statement, the better it will be. So whether you write it out so you can read it word for word, or what I normally do for most of my presentations in court are write bullet points. So I'm writing it on index cards or on legal pads, and I just want to make sure the bullet point is the primary topic that I have to hit. So for sentencing purposes, for my clients, it's normally, how is this going to affect my family? How is this going to affect my employment? What apology I want to make. Those are all the things you want to focus on as bullet points. The last thing I would recommend, where you want to tell the judge you don't want to come back down this path again, that's fine. But that single statement's not strong enough. You need to sit there and tell the judge, I'm not going to go down this path. I have this goal or these goals in mind. If you've got to be incarcerated, the goals are going to be based on when you're released. Judge, when I'm released, in the first 3 months, 6 months from the time I'm released, I'm going to get stable employment, or I'm going to get enrolled in school, or I'm going to do whatever it is I'm going to do. 12 months after my release, I hope to be at this point in my life. 3 years from my release, this is where I want to be. The more specific you can map out your future, the better off you're going to be. Too many times I've been in court and the person really just makes these generalized statements that, hey, you're never going to see me again, or I learned my lesson. The judge wants to not hear that. He wants to hear that you have a course of action, because action really does speak louder than your words. It's your actions that have brought you before the court. Now you've got to be direct in your statements, what actions you're going to take to be better down the road. With this, if the technology works out right, with this video, I'm also going to be attaching the letter that I provide to my clients on how to craft this allocution, how to craft this statement. I hope that you have found it useful. If I can be of any help further down the road, please give me a call at 602-899-2321. Again, I'm Howard Snader with the Snader Law Group. I'm a board-certified expert in criminal law, and for more than 30 years I've been helping thousands of people negotiate their way through the criminal justice system. So again, if you have any questions, please feel free to reach out to me at my office at 602-899-2321. Thank you.